As the oldest alumnus of the University College of the West Indies, I have been given permission to speak from where I sit. Moderator, Pro-Vice Chancellor, Professor Williams, members of the UWI Academia, the Faculty of Law and the Law School, members of the clergy, members of the bar, Your Excellencies, members of the Diplomatic Corps, former Governor General Sir Kenneth Hall, former Prime Minister Mr. Bruce Golding, who I especially welcome because he's one of the few persons who entered Parliament in 1972, still alive today. Distinguished guests as you all are, both those present and online. Ladies and gentlemen, I want to thank you for your presence and your willingness to participate as we gather for a reasoning on the Jamaican Constitution. It is my honor, and I felt it was my duty, to share with you such perspectives as time will allow on the background, the origin, the operation, and the future as we seek to indigenize our Constitution, abolish the monarchy, and achieve full sovereignty at last. I begin with the 30th of May, 1960. I was walking on the main street in Morant Bay. We were preparing for a federal by-election because Robert Lightburn had resigned from the federal House to successfully contest the seat in the 1959 election. And Edwin Allen, who had lost in northwestern Clarendon, was supposed to be the candidate for the seat. As I was walking towards the campaign office for which I was responsible, I saw the unmistakable figure of Sir Alexander Bustamante walking towards me with a crowd of about 30 persons or so. I thought it prudent to try and duck behind the wall. But he had spotted me. And when he came to where I was, he said, "Come here, Sonny. I thought you had followed my advice. I told you long ago to be off to London to study the law, to see if you could be even half as good in the law as my cousin Norman. Instead of following my advice, he has you running up and down the country like mad ants." And then he said, you will soon see it will all come to naught." I didn't understand what he meant. But that night, on his return to Kingston, he announced that the Labour Party, which he led, would be mounting a campaign to leave the Federation. That resulted in a meeting of the cabinet the following day and Norman Manley's decision to announce his intention to hold a referendum. When that referendum was held by a majority of 40,000 persons, the people decided that Jamaica should go on its own. Following that, a resolution of the House, moved by the Premier, established what was a joint committee to prepare proposals for an independent Jamaica. Please remember that by then, Jamaica had attained what was called full self-government in the Constitution of 1959. And even for some matters that were reserved, like external policy, Norman Manley had found a way of getting around it. So, for instance, we had imposed a ban on goods from South Africa, and we had also required visas for persons entering from South Africa. After deliberations, the Joint Committee took the decision that Jamaica would be a constitutional monarchy with a bicameral legislature. And that decision determined the contours and the framework of the draft constitution, and delegations proceeded from two sides to London to conclude the new Jamaican Constitution. I was privileged to have an insider's view of everything that was taking place. In fact, I was required on my way to LSE to stop at the hotel to find what would be going on for the day, and to stop on my way home when they had returned from Lancaster House to learn what had transpired. And when there were receptions and Bustamante and his delegation were present, Buster would say to me, "My cousin gave me hell today." Or when things went his way, he would say, "My cousin was as brilliant as no one else could be today." The Jamaican Constitution was the first of its kind. And among other things, it created the position of the leader of the opposition and vested that holder with certain specific duties and functions. I think you have to understand the context in which those negotiations were taking place. Norman Manley was the premier. Bustamante had just won the referendum. There was no compulsory requirement for an election to be held, although Bustamante was demanding it. And therefore, both were negotiating a constitution when neither knew who was going to be the prime minister and who would be losing and therefore ending up as leader of the opposition. And that is fundamental to any understanding of how the Constitution was designed. So they created a Senate, 13-8, regardless of what was the majority in the House of Representatives, and entrenched certain provisions which could only be changed if you got at least one vote from the opposition side in the Senate. The leader of the opposition was also vested with the right to be consulted on certain critical appointments. And I'm going to have to say a word more about what consultations mean and what it doesn't mean. Bustamante was heard to say very soon, I have to consult, but I don't have to get agreement. And we have to look at what that has resulted in the course of time. There were some issues that had to be resolved in London and, of course, sanctioned by the Colonial Office. But I think it's true to say that the broad provisions in the Constitution were determined by the two parties representative at the talks. Bustamante had a way of saying things in very short, simple, but profound terms. And he announced from the start, I am with the Queen and for the Queen, full stop. He then left it to his delegation. And of course, Manley, the legal scholar, who was steeped in the doctrine of the greatest authority on the unwritten English Constitution, Professor Dicey, was the one who crafted the provisions of the Constitution that not only entrenched the monarchy deeply, but I should point out that if a referendum is held where there is not a 2/3 majority from the Senate, it can't be changed by a simple majority in the referendum. It has to be done by 2/3 majority in the referendum. And please bear in mind that no political party in its heyday, no matter the sweep, has ever won 2/3 of the vote of the electorate. There was, in accordance with the British practice, a separation of powers. But the difference between the monarchical system and the republican system is that each part is headed by the monarch. So it is the monarch's legislature, the members of the cabinet are Her Majesty's ministers, and the judiciary are Her Majesty's judges. And that is why cases, criminal cases, are brought either Regina versus Adijah Palmer or Rex, as it now is, against Storm Campbell. There were some issues like the prerogative of mercy, which resides in the monarch. In Britain, it is exercised by ministerial advice. After a very long debate, they decided that it would be done by a privy council appointed by the Governor General after consultation with the Prime Minister. I must tell you that as Prime Minister, I was very happy about that decision for one simple reason. I didn't want to have to deal with persons who were applying for clemency. Leave it to other persons' hands. One of the big ticket items had to do with the Director of Public Prosecutions. Up to then, it formed part of the Attorney General's department. There were some who wanted to create the office accountable to the Attorney General. There were those who were determined that the DPP should stand alone and be accountable to no one. That point won the day. When you see the age limit that was fixed, believe you me, it had nothing to do with the Pensions Act, because several people who were DPPs went from there to the Court of Appeal. Swaby, Carr, Ian Fort. It came from a very simple view. The aphorism of Lord Acton, power tends to corrupt, and absolute power corrupts absolutely. And since the DPP was accountable to no one, the tenure was determined by an age limit. And if an extension were to be granted, although the appointment is by the Public Service Commission, as is the Auditor General, in that case, it has to be done by the Prime Minister in consultation with the Leader of the Opposition. And I am not making any statement ad personam. I am saying very clearly that the change of that position, which is before the courts and on which I will not comment, runs contrary to the original intent of the position. Another big issue, and we have dealt with that long ago, was when should be Independence Day. Some wanted it on Emancipation Day. Dr. Ivan Lloyd came up with the proposal, first Monday of every August. And you know the processes by which that has been changed. And there was also the question of the valuation and the method of the acquisition of private property, which was subject to judicial review. No entrenched section or deeply entrenched provision can be altered without bipartisan support in our legislature. And fundamental changes cannot be imposed by a simple parliamentary majority. Therefore, real constitutional changes must entail political consensus. Recently, when AJ presented his book, there was a thorough exposition of why we should remove from the Privy Council to the CCJ. But in the context of this presentation, I am forced to indicate why it is essential that we do so to complete our full sovereignty. As a student of the law, I was furious when I went to the Howard Hotel that evening, and I was told that the Privy Council was going to be the final court of appeal. Norman Manley was not known for his patience. He had other virtues. But when I started my protests, he listened to me without interruption. I asked, how could the National Party subscribe to the retention of an apex court that was created to maintain the cause of empire and maintain its dominion through the Privy Council as the final determinant of our legal rights? I asked him, how could you ignore the existence of a brilliant court led by Chief Justice Hallinan, with eminent jurists such as Alan Lewis, Loku, Rennie, which was universally accepted as one that accorded with the highest standards for superior courts based on the common law? And when I was finished, he proceeded to do a demolition job. He said, the Federation is going to be dismantled. The federal court will disappear. We will have, after the independence, to meet with our colleagues and determine how we replace the federal court. And for that reason, and for that reason only, we are putting in the Privy Council as one for simple amendment. We can take it out and put in what replaces it when we have so decided. Argument done. Believe you me, don't sell Bustamante short. If he had wanted the Privy Council to remain the final court of appeal, he would have insisted on its entrenchment. I am equally indignant at a claim that the call for the creation of a Caribbean court as the final appellate body was spawned by either of our political parties and was therefore, at its inception, a partisan issue. It came from Akbar at a meeting on this campus. I can't forget, it was a Saturday, for reasons which I'll share with you. I made the mistake of leaving my chambers at 11 o'clock without getting my weekly allowance. My secretary gave it to my partner, Tony Spaulding, who, armed with my money, went down to Victoria Pier, as we usually did. And he announced, PJ sends his regrets, but says drinks are on him today. When I went home, I saw Tony Spaulding in my living room, as drunk as a lord, without a cent of my weekly allowance. That meeting of Akbar gave 5 compelling reasons why we must have a court of our own. And to this day, I have not heard any argument advanced by anyone that in any way erodes the legitimacy of those contentions. Now, funnily enough, the first action taken by the government was led by the Right Most Honorable Hugh Shearer, because he took the Akbar recommendation to a meeting of heads in 1970, and they agreed then and there on the federal court. There was a long hiatus, and indeed in the 70s, we were concentrating more on Carifta, moving it to a common market, moving it to a community. It is when we began now to move towards a single market that it became obvious we would have to visit with urgency the question of a tribunal. The meeting in Antigua of heads met in caucus. The Prime Minister then was the Most Honorable Edward Seaga. And I quote, "Caucus decided to avoid the option of a transitional involvement of Caribbean jurists in the Privy Council and take instead immediate steps towards the expeditious establishment of a Caribbean court as the final appellate body for English-speaking countries." End of quote. Ozzie Harding, King's Counsel, was a member of the Regional Attorneys General entrusted with the draft framework. Not one single ground has been advanced why this vestigial colonial institution should remain. What changed? The government. And the then leader of the opposition thought he was going to lure me with the fantasy of an indicative referendum. I was never going to succumb to that temptation. The differences between the two parties were reflected in our election manifestos of 2002. Now, the matter went to the Privy Council eventually, and let me say this. I accept the decision of the Privy Council because it is final, not because it is right. Why do I say this? What we lawyers call the ratio decidendi, meaning the reasons for the decision, are fundamentally flawed and indeed reflect a level of contempt which I find repugnant. Because on an examination, the Privy Council was satisfied of the quality of the composition of the court, its protection by a treaty, but it invoked what I call the doctrine of anticipated malevolence. What do I mean? What do they mean by that? Lest one prime minister would go rogue. And they said, one prime minister can interfere with the Caribbean court, but everybody knows nobody can interfere with us. Within 1 year of their saying so, Tony Blair changed the entire structure of the English judicial system and abolished the House of Lords as the final appellate court and instead constituted the English Supreme Court. I have to say that because I'm often misquoted by saying the law is not a shackle. I never said so. And I am sure the jurisprudence that is taught here allows people to understand that there are different approaches to the law. In my view, and I'm persistent in that, it has to be a tool of social engineering. Apart from my pleasure, which is customary, in seeing Mr. Bruce Golding here, he can attest to what I'm about to say. The CCJ is our court. We fashioned it ourselves. We have paid our share for it. And having regard to the debate in Parliament, we made it an itinerant court so it can sit in Jamaica. It has now passed the 10-year test. One of our most brilliant jurists, Dr. Lloyd Barnett, wrote an assessment of the quality of the judgments issued, which I started to discuss with Mr. Siaga in an attempt to persuade him. But unfortunately, he fell ill before that discussion could be completed. During Mr. Golding's tenure, he commissioned quite understandably a study on whether we should have a final court, which is a Jamaican court, as distinct from the CCJ. And the answers are clear. We simply can't afford it. We're paying for one already. And we will be competing with the CCJ from the same pool of talent. Justice has a cost. And if we can find the money, we should use it to improve and perfect our justice system. That is why we all applaud the new remuneration package for the judiciary. I go further. We must retain the highest levels of competence. We can't afford judges of the Court of Appeal who are just getting in their ring hockey where the law is concerned, to be retiring at 70. We should be considering adjusting the age upwards to at least 72, possibly 75. Some cases have come to attention recently. There is a case of Lysine Edwards, where he was acquitted by the Privy Council. But you know why he was acquitted? The Privy Council made resources available for them to do a scientific study which was not available in the court here. And one thing we have to understand, poor people are denied the equality of justice because justice is costly. If Vibes Cartel didn't have the money, his case wouldn't have gone to the Privy Council. But his case should not have gone to the Privy Council if we had in place a system that records judgments of our own Court of Appeal. Because if it had, somebody could have looked on those judgments and found that our Court of Appeal here, Zaka and Rowe, with Rocky White dissenting, had decided that once there is any sign of contamination, you must dismiss the entire jury. I am not oblivious to the fact that right now there is a tide because of the judgment or the way the Adijah Palmer appeal was handled. But please note that the same way the Privy Council streams its hearings live, so does the Caribbean Court of Justice. So, 62 years after our independence, it is more than overdue for Jamaica to depend no longer on an order in council to abolish the monarchy and to vest the judicial arm with the full authority to dispense justice for all as we seek to develop a Caribbean jurisprudence. I repeat, our founding fathers envisaged the establishment of a Caribbean court at the apex. It should remain as a settled national position and not be subverted because of political expediency to be a partisan divide. I move now to the matters pertaining to the reform of other aspects of our Constitution. During the 1978 conversations, the PNP was insistent on an executive president chosen by the electorate. The JLP favored a ceremonial head of state appointed by parliamentary procedures. The Carr Commission, by a majority decision after extensive debate, recommended, and I quote, that the formal head of state should not be an active politician and head of government, end of quote. It proposed that the head of state should be appointed on the nomination of the Prime Minister in consultation with the leader of the opposition, subject to confirmation by a 2/3 majority of the members of both houses of Parliament sitting in joint session. This, it felt, would invest the selection with an aura of democratic approval, and the Republican form would replace the monarchical in a manner indicative of our national identity and consciousness of our self-esteem as a nation. I sought during my tenure to move forward to completing the structures of our independence. It was my view that the process towards our self-definition as a people had to be accelerated. The institution of our own indigenous president as head of state in the Republic of Jamaica must now be placed on the front burner of the public agenda. In order to obtain a consensus on these new constitutional arrangements, I sought and obtained at our annual party conference in 2001 permission to accept a ceremonial head. And let me say this: our constitutions are based on a figment that political parties do not exist. They do, and they matter. And to operate the constitutions properly, we have to take in account the reality of their existence. We were about to see eye to eye, Mr. Siaga and I then, when my good friend Bruce returned to the fold. And Mr. Siaga said to me at the Vale Royal meeting, Bruce has brought some ideas again about the separation of powers. We have to get some time to sort it out. I did know, Bruce, that already there were some other sleepers in the JLP who were also of that view. The net result of it is that we didn't move forward, and with Mr. Siaga's departure, the only meeting that I had at Vale Royal with the new leader of the opposition, Mr. Bruce Golding, he told me then he had just assumed the leadership. He had set up a committee under Mr. Senator Dwight Nelson, and they needed some time. I say this frankly, I have always worked assiduously to obtain a national consensus. I think it is critical to the future of Jamaica that we do as much as we possibly can together in a united way than as differing political tribes. What I did before departure is to change the oath being taken by prime ministers, because it was very hard and uncomfortable to swear allegiance to a foreign monarch. And when we had the swearing in on the 23rd of October, I moved it to Emancipation Park rather than King's House deliberately, because I was able to swear to be faithful and bear true allegiance to Jamaica, to uphold and defend the Constitution and the laws of Jamaica, to conscientiously and impartially discharge my responsibilities to the people of Jamaica. The issue of citizenship has always been a burning question. The British Commonwealth, as it was in 1962, no longer exists. We are now in the Commonwealth of Nations. Once the monarch goes, so must disappear any concept of a shared common allegiance. We changed in 1993 the constitutional rights to citizenship by descent by making sure that women were placed as mothers on equal footing with men as their fathers. And so some people are not only of Jamaican descent by birth, but also entitled to Jamaican citizenship by their descent of their motherhood. In my view, and this is in the report which I support, no valid reason exists for maintaining the provisions pertaining to a Commonwealth citizen other than a citizen of Jamaica who is resident for at least 12 months to be eligible for parliamentary office. The qualifications must be based, in my view, on Jamaican citizenship. I don't want to cause any confusion. Citizens of the Commonwealth are at the present time legally entitled to sit in the House or the Senate. I am deliberately confining my remarks to the constitutionality of any such position. Political considerations are well above my grade in the pavilion. It is my considered view that Section 40 should not be confined to parliamentarians, but extended. In my time, there were 2 appointments I had to make. The people disclosed to me that they held citizenship of another country. I told them, not putting any pressure on you, you have a choice. Renounce and stay where you are. Or if you want to accept this position, because of its sensitivity, you have to renounce. Both, without hesitation, proceeded to renounce and were duly appointed to their positions. There are some positions that I think have to make it clear that allegiance is to Jamaica alone. For example, the Chief of Staff. Otherwise, you're exposing the person to charges of treason. The Permanent Secretary and members of the Defense Board. I raise, without making any proposal, we have to look at questions of persons like the Chief Justice, like the President of the Court of Appeal, like our electoral commissioners and the Director of Elections. All of these require further national scrutiny and discussion and would apply to further appointments as existing conditions of judges cannot be altered to their disadvantage while serving on the bench. I am not moving into the political arena, but I think I have to ground what I have to say by setting out the base on which our democracy rests. The existence and spread of the two major political parties since the grant of universal adult suffrage have ensured smooth transition in accordance with successive election results, and we deserve to applaud ourselves for that. It is commendable, but we cannot ignore how tender and delicate is the plant of the Westminster model, where a first-past-the-post system may still allow a majority of seats, but a minority of popular votes. Lopsided parliamentary majorities often conceal the real margin of the popular will, and the more so when we witness a worrying decline in the number of persons who actually exercise the precious franchise. So, there can be a government in office which in fact does not command the support of a majority within the nation. I believe we should seek in the design of our new constitution to foster a participatory democracy. I would dare to suggest that we can begin with a step that entrenches local government, that gives it a more functional role and greater community involvement in several aspects of rural and urban development as they affect our daily lives. Eradicating political tribalism must be our goal. We have seen what can be achieved whenever we reach a national consensus, and in our own way, fashion and create an institutional machinery to effect it. The Electoral Commission is fitting testimony that we can. It rescued this country from civil war in 1980 and reached a point where, with a 32 to 31 majority, we could see the swearing in of a new prime minister without a single shot being fired anywhere. Here I'm going to make a fundamental point. I believe that we have to change the portions of our Constitution which speak about Prime Minister after consultation to Prime Minister with the concurrence. And I speak as one who had to apply the present system for 14 years. And I will say very frankly, admittedly, there are some times when I insisted on having my own way. But in the majority of cases, by a process of communication and interchange, the leader of the opposition and myself were able to reach consensus on critical appointments. And this is where what is called the Vale Royal talks come in. We cannot overemphasize its importance or its potential. And I will share with you, when it comes to things like the Judicial Services Commission, or the Police Services Commission, or the Public Service Commission, if it became necessary, Mr. Siaga and myself would meet in my room at Gordon House, and we would exchange names, and we would finally agree on a list of persons best suited to fulfill the particular functions. This is a lead-in to one of the provisions in this report of the CRC, which quite frankly fills me with great alarm. It is the proposal of a two-tiered system of the election of a president. It is absolutely unacceptable, must be vehemently resisted, and would totally destroy the purpose and intent and legitimacy of a head of state. Because what it is saying is, nominated by the Prime Minister and after consultation with the leader of the opposition, and if you can't get 2/3, it speaks about taking into account political realities in our democratic system of government. It also provides a solution through the application of the majority rule to a problem where gridlock exists. You cannot afford gridlock in this. There are several things that can be done. You can, in Barbados, it is done by the Prime Minister and the leader of the opposition. If you put that position in, you will not only get 2/3, you will get unanimity. If you don't put that in, and the first nomination fails to get the 2/3, you must treat it like a papal consistory. That is to say, lock them up and don't let them out until you have got a nomination. Then you can let the smoke out of the chimney. We have elected a new head of state. I also have a concern about the proposals for the extension of membership in the Senate. And let me say it very clearly, I am not opposed to a careful consideration as to whether you should get representatives in the Senate other than those which come from the political parties. I am saying that the categories would have to be specifically defined. They would have to provide for the people within that category to do that selection and not vest it in the head of state, because if you vest it in the head of state, you are having then an interference by the head of state in the legislative process, and that you cannot afford. And I'm saying, if you're going that route, consider very carefully whether the representatives of the diaspora should not have some role or some voice. In speaking of I am not proposing it as a settled matter. I am saying if you are going for putting in the church, the private sector, the unions, the NGOs, there's a very important group called the diaspora. So you would have to look at whether or not you are going to include them. And if so, how? Because the oath of allegiance, which those citizens are required to take, make it inconsistent for them to be serving simultaneously in the Jamaican Parliament. And please also note that there are several Jamaicans who have lived, particularly in the United States, for years, had children and grandchildren who to this day operate on green cards because they refuse to take an oath of allegiance which will in any way seem to renounce their Jamaican citizenry. So this matter really needs very careful further consideration. I also am very concerned about the proposal to extend the life of Parliament for new conditions. And the proposal is that could be extended for up to 2 years. I am not for that. If you can have a general election in the middle of a global pandemic, I don't see any reason why there should be an exemption that could permit the life of the legislature and a denial of the people of the right to choose for 2 years in those circumstances. I would also have hoped that, having abandoned the proposals in the Carr report to include impeachment proceedings against parliamentarians, the CRC would have proposed the entrenchment of the Integrity Commission. Let me pose the question, where do we go from here? I note in a letter today that it is being suggested that the report should be laid on the table of the House, that there should be room for public ventilation. I would strongly suggest, as we did for the Carr report, that the report should first of all be debated in Parliament, in both houses, that it should be referred to a joint select committee to permit submissions. And then I think there has to be what I call meaningful Vale Royal talks. what I call a come to Jamaica moment. I believe the reformed constitution must seek to capture popular will, symbolize national values, and inspire us as a land of beauty to become a great people where our destiny beckons. Let us realize that our nation needs peace, needs harmony, and needs justice for one Jamaica, land we love.
Thank you, Mr. Patterson, for your presentation. At this time,